Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the realm of international taxation. For this, we have selected three important cases. The first one discusses the taxability of reinsurance premium received by foreign reinsurer company from their Indian counterpart. The second one discusses the equation of controlling interest as existence of PE. And the third one discusses the characterization of receipts for license to use design and drawings for specific purposes as royalty. Our first case revolves around the taxability of foreign reinsurer in India on the basis of support services provided by its Indian subsidiary. Let's understand what exactly happened in this case.
The assessee in the present case is engaged in providing reinsurance globally to various life and non-life insurance companies. For such purposes, the assessee had reinsurance arrangements with various Indian insurance companies which were negotiated, finalized and executed outside India. As part of such arrangement, the Indian insurance companies pay a reinsurance premium to the assessee company to reinsure their part of the risk, which was accepted by the assessee from outside India. Now, the dispute arose as to the taxability of such receipts because as per income tax authorities, they were liable to be taxed in India as they were earned as a result of business connection in India.
Let's see what the tribunal had finally decided. Firstly, support services provided by the Indian subsidiary of a foreign reinsurer cannot be equated to carrying on of reinsurance business. Secondly, existence of Indian subsidiary cannot ipso facto be understood as PE of the non-resident entity in India. And lastly, auxiliary activities performed by the liaison officer cannot be construed as existence of business connection within the meaning of Section 9, Clause 1, Subsection 1 of the IT Act. Moving on to a second case, the tribunal was approached to decide as to whether the controlling interest is of vital importance whether deciding existence of a PE. Let's understand what exactly happened in this case.
The assessee in the present case is engaged in the business of diamond grading and preparation of diamond dossier. While filing their return, they claimed exemption from offering instructor fee earned from their Indian counterpart by pleading treaty benefits. The department was however not convinced, as according to them, the related concern to which the diamond grading services were rendered constituted a PE, and to that extent, the receipts from such activity would be taxable in India. The department arrived at this conclusion on the ground that both the foreign entity as well as the Indian counterpart together, along with other entities of the group, had in effect established a joint venture business in which these two operated as partners.
Let's see what the tribunal had finally decided. Firstly, mere fact that a company has controlling interest in the other company does not by itself make the other company its PE. Secondly, employees deputed to the Indian subsidiary cannot be construed as service PE if their entire salary cost was borne by the subsidiary and they were working under the control and supervision of the subsidiary only. Lastly, a service PE is triggered if the services are rendered by foreign entity through their employees in India for the period aggregating to more than 90 days within any 12-month period. Moving on to a last case where receipts from supply of design and drawings were taxed as royalty even when only license to use for specific purposes was granted without any transfer of title. Let's see what exactly happened in this case.
The assessee company is a tax resident of Finland and is engaged in worldwide operations of providing innovative and environmentally sound solutions for consumers in the metal processing industry. During the relevant assessment year, the assessee generated some revenue from Indian projects in respect of sale of design and drawings, rendition of technical services, license fees and testing, as well as other services. The dispute arose when the assessee did not offer to tax receipts from sale of designs and drawings as well as income earned from providing testing and other services. The assessing officer, however, treated such receipts as royalty under the Income Tax Act as well as under the India-Finland Treaty. The revenue held that absence of permanent establishment in India for supplying designs and drawings would not save the same from taxation.
Let's see what the tribunal had finally decided. Firstly, income earned from the sale of designs and drawings is not classifiable as royalty or FTS. Rather, such income is said to be treated as business income if the seller of such design and drawings has no PE in India. Lastly, income arising from testing and other services performed abroad can be taxed in India if the payment received is not for the process but for the results of testings which are used in India. With this, we wrap up this episode of Legal Wrangle, and next time we'll bring some interesting cases from the world of excise and customs. Thank you for watching TIOL Tube.